The United States Supreme Court has recently made a decision that's stirring a lot of discussion in the legal and firearms community. In a significant move, the court declined to grant emergency review in a case that directly challenged New York City's strict rifle and shotgun permit requirements. This decision by the Supreme Court had immediate consequences. Because the emergency review was denied, the challenge was later dismissed by the Second Circuit Court of Appeals. That dismissal has now sent the case back to the lower court, which appears to be moving toward throwing it out entirely. The case at the center of this controversy is Schroer v. City of New York. At its heart, it questions the constitutionality of New York City's discretionary licensing system for owning rifles and shotguns. Under this system, it's not enough to simply pass a background check or meet basic eligibility criteria. The New York City Police Department has the authority to decide who qualifies for a permit and who does not, based on its own determination of good moral character. Critics argue that this kind of unchecked discretion allows for subjective and inconsistent decisions, effectively giving the police department the power to deny law-abiding citizens their constitutional rights. The plaintiffs in this case, led by Joseph Schroer, believe that this system is fundamentally at odds with the U.S. Constitution, particularly in light of the Supreme Court's landmark Bruin decision, which struck down similar may-issue licensing systems that relied on subjective judgment rather than clear, objective standards. Initially, Schroer and his legal team sought emergency intervention from the Supreme Court, hoping the justices would step in immediately to halt New York City's permit requirements. However, the court refused to take up the emergency application at that stage, pointing out that the case was still awaiting a decision from a three-judge panel in the Second Circuit. Once the Supreme Court stepped aside, the Second Circuit had the freedom to issue its ruling. But instead of examining the merits of the case, meaning the actual constitutional arguments, the court took a very different approach. It declared the case moot and dismissed it outright. This ruling effectively sidestepped the central constitutional question and has now put the entire lawsuit in jeopardy. With the case in danger of being permanently dismissed by the lower court, Schroer and his team may once again be forced to turn to the Supreme Court, possibly filing a new emergency petition in the hope that the justices will intervene before the issue disappears from the courts entirely. Now, upon review, the district court had actually granted a permanent injunction against certain parts of New York City's firearm licensing scheme. One of the provisions they struck down was the requirement for applicants to prove they were of good moral character before being granted a permit. This was a big deal because, under that rule, you couldn't even get a license without first convincing the authorities of your personal moral standing, something that is highly subjective and, as the court found, unconstitutional under the Bruin decision. That ruling was a major victory for gun rights advocates. However, New York State wasn't willing to let it stand without a fight. The state decided to appeal the decision to the Second Circuit Court of Appeals. At the same time, New York City also took action. They requested a stay on the permanent injunction while the appeal was ongoing. In other words, they wanted the court to temporarily pause the enforcement of the lower court's decision. The Second Circuit granted that emergency stay, meaning the good moral character requirement could still be enforced while the case was under review. In response, an emergency application was filed directly to the U.S. Supreme Court. The goal was to have the stay removed specifically for the good moral character rule, because it was so similar to a provision that had already been struck down in the Bruin case. That emergency request first went to Justice Sonia Sotomayor, but ultimately the full Supreme Court denied the application. They refused to intervene at that stage. With that, the matter went back to the Second Circuit. But instead of reviewing the merits of the case, meaning they didn't actually consider the core constitutional questions, the Second Circuit dismissed it entirely. Why? Their reasoning was that the plaintiff, Mr. Schroer, had already received the permit he was fighting for. New York argued that since he had already obtained the license, there was nothing left for the court to decide. In legal terms, they claimed the case was moot. The Second Circuit agreed. They issued an order saying, "Because Schroer has been granted the very relief he sought, the case before us is moot, and we lack jurisdiction to hear the merits." They also stated there was no indication that New York City had intentionally issued the permit just to avoid the lawsuit, nor that it was connected to the litigation at all. Now, in these types of cases, there are two main arguments that can be used to fight a mootness claim. 1. Intentional mooting. If one party deliberately tries to make the case irrelevant just to avoid a ruling. 2. Issue likely to recur. Even if the immediate problem is resolved, if it's likely to happen again, the court can still hear the case. Mr. Strower argued both points. He said the city deliberately issued his permit in 2024 to sidestep the lawsuit. He also claimed that the city still had the power to revoke or deny renewal of his license in the future, which meant the injury could easily happen again. But the Second Circuit didn't buy it. They said both arguments were unconvincing and instead took the city's word that they hadn't acted intentionally and that they would never revoke or deny his permit unless he did something wrong. Meanwhile, in the lower district court, status conferences were held to address the ongoing dispute. Some of the plaintiffs' earlier motions were dismissed. Then, the city filed a new motion to dismiss, this time directly relying on the Second Circuit's mootness ruling, asking the lower court to throw out the challenge for the same reason. Recently, the plaintiffs filed a detailed brief opposing that new motion to dismiss. Their core argument was simple. The original complaint never asked the court to order the police commissioner to issue a license. The city's voluntary decision to give Mr. Strower a license didn't actually provide him with the relief he was seeking in his lawsuit. In other words, the main constitutional challenge remained unresolved, and the case should not be thrown out. Mr. Strower has argued that the Second Circuit sidestepped the real relief he was seeking. Their position was essentially, well, you received your permit, so you've already gotten what you wanted. But that's not the full picture. What Mr. Strower truly wanted was a permanent injunction stopping the enforcement of the law itself. And that never happened. That form of relief has yet to be granted. His argument is that until such an injunction is in place, this case is far from over. He still has standing, and the court should see it through until that goal is achieved. Now, the case has already gone through a bench trial before the district court, and we're waiting to see how the judge will rule. One of the key questions is whether the court will decide this case is now moot simply because he was issued a permit. That's not just a minor detail. It has the potential to set a major precedent. If the court rules it moot, it could open the door for local governments, cities, states, or other authorities to play a dangerous game in future cases. Imagine a situation where they're losing ground in court. Instead of seeing it through, they could simply hand out permits or make quick policy adjustments at the last moment just to sidestep a legal challenge. That's exactly the kind of loophole this lawsuit is aiming to close. This case also highlights how the Supreme Court's initial refusal to grant the emergency application had ripple effects. By declining at that stage, it allowed the Second Circuit to avoid fully engaging with the case. Instead of examining the actual merits of the arguments, the Second Circuit found a way to label it moot and toss it out. Because of this, the core issues, the true constitutional questions, still haven't been addressed. At nearly every stage, the Second Circuit has avoided looking squarely at the Second Amendment arguments at the heart of this challenge. And that avoidance isn't unique to this court. It's something we're seeing repeatedly in cases involving firearm rights. This is why there's a strong chance this challenge could once again reach the Supreme Court, this time on the final merits. The original dismissal on grounds of mootness essentially served as a final resolution without ever debating the heart of the matter. At its core, this case challenges the requirement for a possession permit for rifles and shotguns within a city. It's a fight that could impact laws in numerous cities and states across the country. The argument is that these types of permitting systems violate constitutional rights, especially when viewed in light of the Supreme Court's decision in the Bruin case. As this legal battle develops, it will be important to watch closely. The outcome could shape how far governments can go in imposing permit requirements for firearm ownership. I'll be keeping a close eye on this case and will share updates as soon as new developments emerge. If you found this breakdown informative and want to support the channel, the best thing you can do is subscribe so you don't miss future updates. Thank you all for your continued support.